In the first part of this series, I described the history of annulments and adoption, but that was generally from the perspective of adoptive parents who wished to cancel an adoption and give a kid back to the state, or give the adopted person informally to somebody else. But in the end, I posed two questions to highlight a different perspective, our perspective. That is, people like me, an adopted person. I asked, if there's always been a formal or informal right of return policy for adoptive parents, with remedies to fix what they believe was a raw deal, what about an adult adoptee who got a raw deal? Should there be a right to annul your own adoption? Yes, there should be. And it turns out that a number of states have also answered that question with a yes. For decades, at least 2 states recognized a right for an adult adopted person to void their adoption, and a number of other states had provisions that would allow vacating or annulling an adoption under certain circumstances. Maine, for instance, had for many years a provision that allowed 2 or more persons, for good cause shown, to seek and obtain the annulment of an adoption. Other states had general provisions that allowed vacation or annulment by anyone, though the law usually mandated strict time periods, and was typically only available while the adoptee was a child. West Virginia and Vermont, however, had much broader and nearly identical provisions for decades. West Virginia, which for nearly 100 years recognized the right to void your own adoption, had a law that was simple, though it required the adopted person to act as soon as they became an adult. The law in West Virginia for years stated that if the person thus adopted is adopted while a minor, he may within 1 year after becoming of age sign, seal, and acknowledge before proper authority, in the county in which the instrument of adoption was filed, a descent from such adoption. Such instrument of descent shall be recorded in such county court clerk's office, and upon the filing of the same, the adoption shall be void. You would think that this right, a right to end your own adoption, is outdated and maybe a throwback to a different time. That is, we're not going back there again. That's wrong. It's not outdated. It's necessary today to restore autonomy, and recently West Virginia legislators have introduced bills that would recognize that right to autonomy. One bill, first introduced in 2019, would reinstate the right to annul your own adoption. It provides that any adult resident who has been previously adopted by order of a West Virginia court may petition a circuit court for a court order annulling the adoption. Upon granting the petition by the court, all legal rights and privileges granted pursuant to state law by the adoption are null and void. Annulment or vacating an adoption is really about one thing. It provides genuine autonomy to an adopted person, an autonomy that had not existed during their childhood when the adoption was facilitated and determined to be in their best interests, but almost always without their direct input. Today, however, the right to annul or vacate an adoption would provide needed autonomy to people whose best interests as adults mean terminating an adoption that never worked for them or that they no longer want. That autonomy exists today, but we call it something else. We call it adult adoption. Adult adoption, however, is not the same as annulment, though it does provide that adoptees are trusted as adults with their own decisions over who may be their parents. That is, an adult adopted person, or any adult, can be adopted by another adult, and it only requires the consent of both people. This has been done for millennia, going back to ancient Rome, largely for purposes of inheritance, but in more modern times for purposes of arranging a family that fits who you are and how you identify. While there are a few limitations in some states with adult adoptions, usually concerning the age difference between the people involved, all it takes in most states is the consent of both the adoptee and the proposed adopter. After all, everyone in this legal relationship is an adult, and we all presume that they know what is in their own best interests, don't we? So if you can already legally rearrange your own parentage through an adult adoption, which provides a semblance of autonomy, what's the difference between that and ending an adoption on your own? There's not much difference. 1. Adult adoption creates a new parent and terminates the prior parental relationship. The other, annulment, terminates the adoption and leaves the adoptee completely autonomous, without legal parents. That is, the adoption no longer exists. Annulling your own adoption is not without its issues, which we can resolve, and if we are serious about reinstating or securing a right that we should have as adults, we need to answer a few questions to get there. In fact, even if a bill like the one in West Virginia became law tomorrow, we'd still need to figure out a number of things. These include restoration rights, which basically has two issues. One, does annulment restore your own original birth record? That's easy to answer. Yes, this is already the case in current law in most states. That is, annulment of adoptions leads to the restoration of the prior original birth record. The second restoration right is more complicated and involves the complexity of human relationships. That is, what prior parental rights, if any, are restored through the annulment or vacation of an adoption. That is not an easy question to answer, and it will need to be sussed out. Same goes for intercountry adoptees whose adoptions were critical to make them U.S. citizens. How would annulment affect that citizenship, and what do we need to watch out for? These and likely other questions, however, are issues, not barriers. In other words, provided we can establish a right to annul your own adoption as a simple procedure, then we are certainly able as adults to work out the more complex cases that may arise in certain requested situations. I believe very strongly there should be a right to annul or vacate your own adoption, and that right should be simple and straightforward with one result. It would end an adoption and restore the original birth record if so requested. Other issues, such as inheritance rights, parental rights, citizenship if it's affected, should be considered as a separate part of an annulment or court proceeding, but only if needed and only at the request of the adopted person. That is, if they want to restore additional rights or determine new legal relationships, then those requests may require additional proceedings and may at times involve notifying other people who would be affected by it. These would be the more complicated annulments, but it is up to the adopted person to raise these issues and pursue them if they choose to do so. This is both an easy issue and a hard issue. It is easy because annulments of adoptions once existed for adopted people, while at the same time for adoptive parents, annulments have almost always existed, even to this day, both formally and informally. So it's not a stretch to reestablish a right we once had, or at least should have today. It is time to work toward recognition of the full autonomy of adopted people and to support it as legal autonomy to be free of an unwanted adoption. Will it be something that most adopted people pursue? No, but it would be available to those who need it.